welcome to the Charity Bite Size webinar. Did you know that in 2014, the total charity legacy income was estimated to be £2.2 billion, and in 2024, only 10 years on, it has increased by 105% to £4.5 billion. Charities are increasingly dependent on their charity legacy income to progress their charitable objectives. During that same 10-year period, the number of probate disputes has increased by a whopping 46%. What does that mean for you as charity legacy officers, finance directors, trustees and the like? First of all, it means that if you haven't come across a probate dispute yet, then it's only a matter of time. But when you do, it is crucial to have a solid understanding of how to manage that situation, because it could have a very significant impact on your charity in the short term as well as in the long term. Let's look at what we're going to talk about. Firstly, I'm going to try to introduce you to the different types of claims that you might expect to come across, covering the will validity challenges, claims under the Reasonable Financial Provision 1975 Act, a glance at proprietary estoppel claims. After that initial section, looking at the types of claims that you'll see, we'll move on to the kind of approach that charities might want to adopt rather, in respect of legacy disputes, and look at some practical suggestions when you are engaged with legacy disputes. Who am I? I'm a partner at Birketts, and I'm head of the Charities Legacy Disputes team, where I have the honour, the privilege and the good fortune to lead an exceptional team of lawyers who specialise exclusively in trust and probate disputes and who are passionate about the charity sector. If you have any questions, please get in touch with me afterwards. Don't worry too much about notes. We will be circulating the slides after the webinar. Without further ado, let's look now at the will validity challenges that you might expect to come across. There are 4: non-compliance with Section 9 of the Wills Act, lack of testamentary capacity, want of knowledge and approval, and undue influence. And the first of those is non-compliance. Issues with whether or not a will has been properly signed or witnessed. We know it has to be in writing. We know that a will has to be signed and attested in the presence of 2 or more witnesses. But even now, I have on my desk a case for a charity where a will has been signed and it has, on the face of it, been witnessed. But on looking into it a bit more, it turns out that the will was posted by the testator to the witnesses, and it will not be valid. Under this heading, you can categorise also fraud, forgery. They are the most interesting of cases, where you can get forensic document examiners looking at the documents, the wills, the paper, the ink, the history of it, and the most fantastic scientific tests. They are also very rare cases. They are no less interesting, but they are rare indeed, but they should not be dismissed. Next on the list, where we are looking at will validity challenges, and let me start off and say as well that looking at will validity challenges, we're looking to whether or not a will is going to be valid. If it's not valid, you're going to a previous will, and if there's no previous will, then you're going to an intestacy. That's what we're looking at here, setting aside the final will. So with want of knowledge and approval, with the sprightly case of Barry and Butland being the leading case, but certainly not the most recent, you'll be pleased to know, whether or not, fundamentally concerned with whether or not the terms of the will properly reflect the testator's intentions. Now, if the will has been properly executed, there is a presumption that the testator knew and approved of the terms of the will. But that presumption can be rebutted in certain circumstances where it smells a bit fishy. For example, the will was prepared by the beneficiary themselves. The testator may have been vulnerable. The will might contain unexpected or radical changes, some extremely unexpected typos or things like that, where you just think, actually, I'm not sure that we can presume that the will on the face of it, just because it's been signed and witnessed as a will by the testator, can be presumed to be valid and to reflect their intentions. Now, if there are such suspicious circumstances, if it does smell that fishy, it is for the person seeking to prove the will to show that the terms of the will properly reflect the testator's intentions. That can be difficult if the will is complicated, if it was obtained behind closed doors, for example. Next up on the will validity claims, lack of testamentary capacity. Increasingly common these cases as people are living longer, but not necessarily in better mental health towards the end of their life when they're still making wills. It's a 4-part test devised by the case of Banks and Goodfellow, another good 1800s case, but still good law today, although it is also subject to some review potentially under the law reform. To have mental capacity to make a will, the testator must understand the nature of making a will and its effect. Effectively, the testator must comprehend that they are creating a legal document by which they are disposing of their property on their death. Secondly, they need to understand the extent of the property that they're being disposed of. They don't need to understand the full exact value of every asset they own, but they must have a general understanding of the nature and extent of their estate. They need to understand and appreciate the claims to which they ought to give effect. The testator needs to be able to consider the people who might have a moral claim of their estate, family members, dependents, and weigh those claims up rationally. And they must not be affected by any disorder of the mind that is going to affect their disposal, the disposal of their assets in their will. As I say, these cases are becoming more and more frequent. They rely on you getting their medical records. They rely on you getting expert reports. They are not common, but they are certainly far from uncommon. More uncommon are cases of undue influence. This is the final heading on the will validity. Here you are looking at whether or not someone is effectively being coerced, where someone is being pressured into making a will in terms that they would not otherwise do, but for the exercise of pressure by another party. Where that person, the testator, is being deprived of their own free will. These cases are incredibly difficult to prove because they're inherently improbable, in that it is more probable that someone was simply discussing or encouraging someone to make a will in terms that favoured them than they are actually coercing them. It used to be that you started from the premise that to show undue influence and coercion, that coercion had to be the only viable hypothesis. That's not quite the case, since rare and rare that test is thought to be slightly too rigid, but you get the idea of just how difficult such claims are to prove. Now that's it for will validity challenges, where a will is looking to be set aside in favour of an earlier will or an intestacy. Particular note to you with will validity challenges, you might be, as charities, claimants or defendants. You may choose to challenge the validity of the will in favour of an earlier will. Equally, you might be the subject of a claim against the will under which you benefit. That is not so in claims for reasonable financial provision. Claims for reasonable financial provision under the Inheritance Provision for Family and Dependents Act 1975, catchy name, generally known as 1975 Act for short. Charities will only ever be defendants. The claimants are going to be spouses, children, cohabitees, or dependents. You're not saying that the will should be set aside in favour of a previous will or in favour of intestacy. You are saying that because of my relationship, the claimant, I should say, is saying that because of their relationship with their testator, and because of their financial circumstances, their wider circumstances, their health needs, then they should receive an award or a greater award than they receive under the final will. In my experience, charities find themselves particularly vulnerable to these claims because charities will not usually be able to show a competing need in the same way as an impecunious individual might. Equally, it is a lot easier for claimants to target charity beneficiaries than an elderly surviving relative, for example. You can see the vulnerability there. Next up, proprietary estoppel claims. This is where a testator has made a promise to the claimant, which the testator has basically failed to make good upon in their lifetime or in their will. There are 4 limbs of promises made by the testator, reliance on those promises to their detriment by the claimant, to such a point that it would be unconscionable, fundamentally wrong, for the testator to not have made good on that promise. I've got there a picture of a farming family, and those are the most common types of scenarios that you have in proprietary estoppel claims. Typically, a farming father promises to their oldest son that the farm will be theirs on their father's death. The son works for decades for low pay, long hours, difficult conditions in the expectation of receiving the farm on their father's death. If the father doesn't make good on that promise in his will, then the son can bring a proprietary estoppel claim to satisfy the promised interest. Now, if you think through what that entails, you immediately come upon quite a significant problem. If it is determined that promises have been made, that the claimant relied on those promises to their detriment, how do you make good on the promises? Should the claimant get exactly what they were promised? Should they get part of what they were promised? Would that be fair and right in all of the circumstances? It is not a straightforward answer. They are not straightforward claims to produce. They can go to trial. They're often negotiated, thankfully, but they can be very costly arguments to have with very uncertain outcomes, similar to 1975 Act claims. These are not comprehensive claims. They're not a comprehensive list of claims that you might come across, rather. I've listed others here: will construction, rectification claims, problems with executors, removing executors who are being difficult to trustees. Potential financial abuse of the testator during their lifetime might mean that you want to go and explore whether or not money should come back into the estate, thus increasing the residue, potentially increasing that which the charities will receive. There might be third-party claims. There are a raft of issues, poorly drafted wills where you get this wrong charity name, the wrong charity number, ambiguous wording, conflicting clauses. We can't cover them all, but we cover the main ones that you are likely to come across. And you should, I hope, now have a fair understanding of the different types of claims. The will validity challenges, setting aside a will in favour of a previous will or an intestacy. Claims for reasonable financial provision for an award from the estate. Claims to interests and assets or the entire estate under a proprietary estoppel claim, for example. And an idea of the other kinds of claims that might come across your desk. Now, when it comes to how do you deal with that? How do you deal with when you come in on a Monday morning, you've had a nice relaxing weekend, and on your desk there is a letter of claim saying, "I'm terribly sorry, but we're actually claiming against this, challenging the validity of this will, or we're making a claim under the 1975 Act, or actually the estate is not worth what you think it is because of our proprietary estoppel claim." How do you deal with that? What about if you receive a letter and that letter says, do you know what, you're a beneficiary of this will, but this will is actually quite fishy. You're a bigger beneficiary under the previous will, and we think that there might be evidence to challenge this latter will. You might be the claimant in that type of situation. How do you go about it? There's no perfect answer to it. It's going to be a balancing exercise based on all of the different factors in front of you. On the one hand, you have a duty to maximize your income. You owe obligations to the donor to respect their wishes, to your beneficiaries to advance your charitable objectives, and to the Charity Commission on a regulatory level. On the other hand, you have the litigation risk, everything that goes with pursuing that claim or defending that claim, your charity's own costs. How are you going to fund it? What impact is that going to have on your charity internally? What about paying the risk of paying the other side's cost if you lose adverse costs as they're known? That's a big risk to a charity. What about the inevitable internal time investment? For you as finance directors, legacy officers, it's going to be a massive investment. What about the stress of litigation on all of those involved? We think about stress of litigation on litigants themselves, but legacy officers, those who are in charge of managing these cases, are not immune from that. What about the impact of the delays in getting a legacy? Is it better to negotiate and get less than to pursue it all the way? And then the very big one, potential reputational damage, the one that can often be quite a crippling factor in the thought process of many charities. How could this make us as a charity look if we pursue a claim or if we defend a claim? You do have some ways of dealing with it. This is not a perfect answer to the issues that you will face, to the questions that you will be asked, but there are some general principles, your approach and how you can approach them. To those of you who have emotional intelligence, which I'm sure is the vast majority, if not all of you, they will be self-evident. If someone comes to you with a claim, the worst thing that you can do is to be dismissive, to not engage with it. You need to listen. You need to be sensitive and you need to be empathetic. To those of us in the charity sector, this is not a new thing, and so I won't labour that point. I will labour perhaps this one, the need to be firm. If that is one thing that charities sometimes struggle with, is decision making. Dealing with a situation in a way that you know is not making you feel comfortable, you know you're not happy with it, you know the risks, and you know that you are exposed potentially on a PR level, on a cost level or otherwise, but being able to grab the bull by the horns and taking it ahead anyway and making a decision. Charities cannot afford to be aggressive, but they certainly cannot afford to be indecisive. Indecision costs money and is just as much a risk to the charity in terms of reputation as being aggressive. You cannot be hamstrung by the fear of the PR impact. You need to be strategic. You always need to think proportionality. What is the cost? What is the time? What is the risk? And the big one maybe linked to the being firm, but you need to be proactive. Being reactive can lead to indeterminate delays, increased costs, loss of control. Take control, be engaged, lead the narrative. If necessary, issue court proceedings yourself if things are not moving forward. There will be other beneficiaries who will be desperately grateful to you for taking a proactive involvement in any proceedings in order to make progress. Here are some more practical, detailed solutions. Also, none hugely groundbreaking, but they are important. Get early advice. For that, you will need to build relationships with solicitors that you can trust and who will be happy to take a call, to talk things through and to give you a steer. Consider alternative funding arrangements. This will depend on the solicitors that you speak with. Your chosen legal advisors. I can't speak for everybody. We tend to offer fixed fees for charities so that they have some certainty, or they at least have a choice of going down a fixed fee route, either for set jobs or certain parts of jobs. You can sometimes go into no win, no fee type arrangements. And what we've tended to do also, sometimes limit the costs to that which can be recovered from an opponent, which is quite comprehensive and very appealing to a lot of charities. We don't have it on the slide there, but there's also mitigating the charity's exposure. So we talked about the costs involved in pursuing a claim or defending a claim. But what about the risk of an adverse cost? If you lose and you have to pay the winner's costs. For that, explore after the event insurance. It's known as after the event insurance, or ATE for short. It's an insurance policy. You lose, they pay out instead. Not always available, certainly not always appealing because of very high premiums, but it might be a very valuable solution. Caveats, warnings, and appearances. Caveats are a tool. They are used to prevent probate in the context of a will validity dispute. You enter a caveat, probate will not be granted until that caveat is removed. One of the processes for removing it is that it can expire after 6 months. It can be removed voluntarily, but otherwise it can be warned off. That's the second stage there, warnings. Effectively, you're saying, remove that caveat for the following reasons. If that caveat is not removed, the next stage is to say, no, I'm not removing the caveat. That's called an appearance. That makes the caveat permanent, and it can only be removed by complete consent or the approval of the court. Now, I've mentioned that here because, firstly, is a caveat appropriate? It is not appropriate unless the validity of a will is being challenged. It is not appropriate, for example, in the case where I am now with charities, where the charities are unable to obtain probate, or the executors are unable to obtain probate in favour of the charity beneficiaries because of a caveat in a proprietary estoppel claim. Nothing in a proprietary estoppel claim justifies a caveat. Unless that caveat is removed, we may have to go to court to say to the court, you won't remove it, it's not appropriate for the following reasons, and therefore you, the court, must remove it by way of one of your orders. Warnings. People often say, oh, there's a caveat on there, let's just put in a warning and try and get rid of it. If you do that, and they have not, the caveat tool has not completed an appropriate degree of investigations to satisfy themselves that the will is valid, then they will automatically, in a lot of cases, automatically put in an appearance. What you've done is effectively made the caveat permanent, potentially unnecessarily. Only put in a warning if you are ready to apply for probate, or the executor is ready to apply for probate. Otherwise, you risk potentially having to get the court to remove the caveat where it could have been removed by consent. Always consider ADR. ADR, alternative dispute resolution. We talk about settlement, negotiations and the like. Often that goes down to mediation, especially for charities. Mediation as an alternative to litigation or negotiations by an inordinate number of offer exchanges can be cost effective, it is confidential, and is a great deal quicker than going to trial. Excuse me for a minute, big cough. So mediation, but if not mediation, then there are other ways of doing it. Early neutral evaluation, or FDRs as they've become known, where you get a steer from a judge or potentially just a third party, a professional, naturally a barrister perhaps, or a retired judge can give you a view, potentially on a binding or non-binding basis. There are options. I'll put there use of court applications. Here we're talking about directions, limited grants. We're saying just because you are, if you are in court proceedings, you needn't be afraid of being proactive and engaging with potential applications to the court that are going to further your agenda, help you. So applications to prove a will in solemn form, to remove a caveat, applications for a direction from the court, for declarations from the court in respect of certain things, just to reduce the number of issues in disputes, applications for a limited grant if you can't get a full grant but a property needs to be sold or should be sold because otherwise it's just hemorrhaging money, it's potentially devaluing, there's potentially a very good purchaser for a good offer. Instead of completing the entire argument in a short space of time, which is going to be unrealistic, you can get a limited grant that enables a sale of assets, those proceeds to be held pending a court order or an agreement between the parties. So applications, my only point is that there are options that you can explore. I'm going to finish broadly on a cautionary tale. The picture you have there is of Dr. Gill, Christine Gill. She was a professor. It concerned the validity of the will of Miss Joyce Gill, Dr. Gill's mother. She left the residue of her estate to the RSPCA and expressly excluded her only daughter. Quite a surprise to Dr. Gill. She successfully challenged the will on the grounds of lack of knowledge and approval. She had brought proceedings on other grounds as well, and it's a very important case for charities now and others for a variety of reasons. But she brought it on the grounds of proprietary estoppel as well and undue influence. Those weren't considered in the event by the Court of Appeal. The Court of Appeal said no, that Mrs. Gill did not have requisite level of knowledge and approval because she suffered from agoraphobia, panic disorder, which fundamentally impacted her ability to understand the terms of the will. Effectively, she was put in a room outside of her comfort zone with third parties in such a position that she simply could not have understood what and appreciated what it was that she was agreeing to in that context. The burden was on the RSPCA to prove that in this instance that she had, and they were unable to do so, and the judge set that will aside. Dr. Gill won. The lesson. The RSPCA was said by the judge to have adopted an uncompromising and adversarial stance. It had resisted settlement discussions and offers of mediation. That is extremely unusual. This was a while ago, don't get me wrong, this was over 15 years ago, but this was very unusual even then, to have resisted mediation in this particular way, to have adopted the position that they had was odd, but the point is it can be done, even by big charities being well advised. 4 years on that dispute, it went to the Court of Appeal after the RSPCA not only lost their interest in the estate, they had to pay costs. At the time, it was estimated to be £1.3 million in all, their costs and the other side's costs. There were no win, no fee that impacted that. I don't know the eventual sum. I'm sure it was negotiated and reduced, but even so, a very significant cost order. And the reputational damage was significant. It had an immediate long-term impact on their legacy income. Can't really ascertain exactly what that impact was, but if you look at the statistics, then their income certainly reduced having regard to inflation in the immediate years after that. So these cases can be well managed. They can be poorly managed, and the impact can be significant. But if you do approach things well, if you approach things proactively, if you approach things sensitively, empathetically. If you get the right legal advice and you are sensible in your approaches and your litigation conduct, then it needn't be as scary, it needn't be as daunting, and it needn't be as negative as you might think. I'll leave it at that. But if you have any questions on anything we've discussed, or if you have a case or a situation that you want to discuss, do get in touch. This is my team, and we are supported by an excellent wider charity team that can also help on other aspects where we specialise on the charity legacy disputes. These guys will help you on a variety of other issues. Thank you very much indeed for your time. I look forward to working with you. Bye.